Howdy, my name's Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're going to be continuing our series on the dirty little secret of criminal law. Today's crime is going to be DWI on marijuana. And so the first question I get here a lot is, can I be arrested for driving while intoxicated, drinking and driving, what most people say, if you've been doing marijuana? Well, it is in fact called driving while intoxicated, and you can be arrested if the substance that you're intoxicated on is marijuana. There's not a list of substances. It says any drug, any type of substance at all that is, when introduced into the body, can affect the normal use of your mental or physical faculties. Another question I get is, how do you defend a marijuana blood test? Well, officers take blood in almost every one of these cases, and the main defense that we have is related to that blood test. Because there is no .08 standard, they have to prove that the THC in your system, if there is any, was affecting you. And so there's two different types of results that they typically show on these lab tests. One is for THC metabolite. That just shows that you've ingested or used marijuana sometime recently. It does not mean that your body is being affected by the marijuana. The DPS lab analyst is not going to be able to say that you were affected and lost the normal use of your mental or physical faculties due to the introduction of THC just based on a metabolite. But the problem is for the state, is they can't say that even if you have a delta 9 THC content. And that's the other lab result that they will show, is a delta 9 THC content. That would be potentially affecting someone's mental and physical faculties if there is a delta 9, but you don't know that just because of the blood test. And the DPS analyst will say this on cross-examination. They will admit, I cannot determine whether or not someone had lost the normal use of their mental and physical faculties. And so it goes back to, how does the person look on video? Did they make any admissions to the officer that they weren't feeling like themselves? Things like that. That's the kind of stuff that a prosecutor is going to use to try to convict somebody. And that's the kind of things we attack in order to defend the case. What is the punishment for a DWI marijuana case? Well, because we don't have that .08 standard, it's not really subject to the same levels and changes of punishment that a DWI on alcohol would be. So for example, a DWI 0.15 or greater alcohol test, that's a Class A misdemeanor. So almost every DWI on marijuana alone is going to be a Class B misdemeanor. It's just going to be a driving while intoxicated first offense. If it's your second offense, it would be a Class A. If it's your third or more, it would be a third-degree felony. And if there's a child under the age of 15 in the car, then it'll be a state jail felony. So what is the dirty little secret of DWI marijuana cases? Well, I would say that it is this. First, the fact that you don't have a .08 standard makes it very difficult on the state. And so the dirty little secret here is that they should be getting a drug recognition expert every time they suspect a DWI with marijuana. Because at the trial on a case like this, they're going to have to prove that you lost the normal use of your mental and physical faculties. Even if they have a blood test that has delta 9 THC in it, it's basically meaningless. All that it's going to say is, yeah, the same thing maybe everybody already knew, that the person had smoked marijuana. Maybe there was already an admission to smoking marijuana. All that does is show that the person smoked marijuana. It does not show that they were affected by it. The lab analyst is not going to be able to testify that you're affected by it. So it's got to be that officer on scene. If he's not trained as a drug recognition expert, he is not necessarily going to be able to testify well about that. So if you look good on video and it appears that the evidence really is pointing that you have not lost your normal use of your mental and physical faculties, then it is not illegal to do that. Driving while intoxicated is only a crime when you have lost the normal use of your mental or physical faculties, or you have a greater content of alcohol, 0.08 or more. That's it. And so I would say that's probably the dirty little secret there, is that it's definitely going to take more than a positive test showing marijuana to convict you of this crime.